Welcome to today's episode of An Interesting Case. If you're a returning viewer, welcome back, and if you're new, also welcome, and I hope you'll find the video interesting. If you do, please like the video, leave a comment, and subscribe for more videos like it. Also, please be aware that if you want to read a written account of this case, the case is available in blog format, along with the links to the source materials used at bylawhelp.com. Today we have the case of the Forbidden Shed, or to use its correct legal name, the case of Surrey City versus Koonar. This is a short case, but it still touches on some interesting topics. It is about an unusual shed that some residents of Surrey, British Columbia, built in their backyard, and how that landed them in some trouble with the city's zoning bylaw. The story begins in the spring of 2022 when an official with the city of Surrey became aware of something odd about the property in the residential neighborhood of the city. The property in question was the home of Mr. Jaswinder Koonar and Mrs. Praveen Koonar, and the official found that there was a shipping container located on the premises. The Koonars reportedly had modified the container, installing a door and windows, and had begun using it as a storage shed. This was a problem, though, because the city of Surrey had a zoning bylaw which expressly stated that shipping containers were only permitted in industrial areas. There was an exception for a shipping container to be in other non-industrial areas, but only on a temporary basis when construction was occurring on the property. This was to allow for the storage of construction materials. The Kunars admitted that there was no construction ongoing on the property, telling the city that they were using the storage container turned shed for storing various property which belonged to their children while they were away at university. The city directed the Kunars to remove the shipping container, issuing them a letter on April 11th, 2022, which gave a deadline for removal of May 9th, 2022. After receiving the letter, Mr. Koonar requested an extension of the deadline until June 14th, and the city granted this. However, in July 2022, a city official noticed that the shipping container was still present on the Koonar property, and so the city again advised them that it needed to be removed. Some time then passed, but the container continued to sit on the premises. Therefore, in November 2022, the city issued a letter warning the Koonars that if the container was not removed by March 2023, the city of Surrey may begin legal proceedings in court against them for violation of the zoning bylaw. Following the letter warning of the legal action, Mr. Koonar again asked for another extension of the deadline, requesting it be extended until September 15, 2023. Mr. Koonar stated that the reason he needed this was because he needed time to empty the shed of its contents, that being the belongings of his children. The city of Surrey granted this second request for an extension, but on September 7, 2023, Mr. Koonar came back and requested a third extension, this time until January 31st, 2024. And Mr. Koonar's justification for the extension was that the graduation date for his children had been delayed, and thus they would not have time to attend the property and empty the shed of its contents until later. It seemed the city was a little skeptical of this request for a third extension, and it requested that Mr. Koonar provide documentation to show when the children would graduate. It was then discovered that the graduation date for the children would not be until April 2024. Consequently, Mr. Koonar then asked for the deadline to be moved until April 2024. The city was unwilling to agree to this and directed Mr. Koonar that the deadline would be extended no later than October 15th, 2023. This final extended deadline was not met, and so in November 2023, the city of Surrey filed a petition with the Supreme Court of British Columbia seeking a court order to require the shipping container's removal. After legal proceedings began, the city made a final attempt to resolve the issue by offering to extend the deadline for removal to May 2024 if the Koonars would sign what is known as a consent order, agreeing to remove the shipping container by that date. A consent order is a legal instrument, essentially the same as a judge's order, except that persons voluntarily agree to it, and hence the name consent order. A person is legally bound to comply with a consent order in the same manner as they would have to comply with a judge's order. Mr. Koonar was not willing to sign the consent order, however, and so the matter proceeded to trial before Justice Jeffrey Gomery of the Supreme Court in February 2024. At the hearing, the main point of argument was whether the structure was prohibited by the bylaw or not, as Mr. Koonar argued that he had modified it into a shed and it was no longer a shipping container. He noted that he'd never seen a shipping container with a door with a door and windows, and therefore it must be a shed and not a shipping container. Unfortunately for Mr. Koonar, this argument was not persuasive to Justice Gumry, who pointed out the wording of the bylaw. It specifically stated that a shipping container was, quote, an enclosed unit used or intended to be used for storing and transporting goods via ship, rail, or truck, whether or not it is actually being used for such a purpose, unquote. Justice Gumry commented that it was apparent that the bylaw was concerned about maintaining the character of residential areas by restricting what could be placed there. The justice opined that those who had drafted the bylaw had been proceeding on the basis that the appearance of shipping containers was not consistent with residential neighborhoods. He went on to state that in the photographs of the disputed structure which were presented, it looked like a shipping container to him, pointing out a serial number and other markings on it. Consequently, the justice ruled that the object was still a shipping container, even though Mr. Koonar had made modifications to it. Justice Gumry then issued an order giving the Koonars 30 days to remove the shipping container and awarded $1,000 to the city of Surrey to partially cover the legal costs incurred in taking the matter to court. So there ends the shipping container saga. What can we take away from this? Well, it reminds me that even when municipal enforcement officials give property owners who are breaking the law repeated chances to voluntarily correct problems, sometimes people will just refuse until you take the matter to court. Having worked as a bylaw enforcement officer myself in the past, I have dealt with some similar situations where people just doggedly refuse to listen to warnings. It's unfortunate because the stress and cost of court proceedings could easily be avoided, but I guess that's just how the cookie crumbles sometimes. Well, thank you for watching. I hope you found the video interesting, and if you did, and you haven't already, please give the video a like, leave a comment, and subscribe for more videos like it. Until next time, take care.